Welcome, and thank you again for joining us. I just wanted to, by way of introduction, introduce myself. My name is Fuji Whittenburg. I'm an attorney at Wolfsdorf Immigration Law Group, and this is a free webinar that we typically provide to a lot of the local universities, and we realized a lot of people were really enjoying it, taking advantage. So, if you have questions after the webinar, if there's time, I will try to answer some, and you can feel free to type them, as the webinar is coming along, and I try and get back to people afterwards, but it's really difficult for me to go through and also answer the questions. But feel free to please use the chat function, and you can type in some questions, and I'll try and get back to you afterwards. If not, my email address is here as well on this first page of the PowerPoint. You can try and email me as well, and I'm more than happy to, get back to you with my thoughts. Obviously, none of this is intended to be direct legal advice. Each of your situations is, is going to be pretty unique and depend on your personal circumstances. But, I think it should give you an idea of what your options are. And, generally speaking, I hope that I'm able to answer your questions as we go through the webinar. Okay, so that's pretty much it. You can go to our website to receive our newsletter, and then a couple more quick plugs. You can like us on Facebook and follow us on Twitter. But that means we can now begin our PowerPoint and presentation, work visa options after OPT. Okay. CPT and OPT are, for most of you who are F-1 students, CPT is something that some of you have taken advantage of, which allows you to work during the school year. You can work part-time, and then OPT is what I'm assuming most of you are either in OPT, in your OPT time period right now, work authorization, you're about to be, or you're about to apply for OPT, and that's optional practical training. And how long does that last? That lasts for 1 year. It's 1 year of work authorization you receive once you graduate from your program, and it's not even technically once you graduate. It's once you finish your degree requirements. You can actually, you can apply for OPT. There's something new that's also called STEM OPT. Basically, it's a 17-month extension of OPT if you're in the science, technology, engineering, and math areas, and they've expanded this list of STEM degrees. So you should really look at we provided a link here. You should see, because for those of you who are already in OPT right now and you're coming up on your 12 months, you may be able to get a 17-month extension depending on your degree, and hopefully it's on the designated list. You can get the 17-month extension. It's not automatic. The job has to directly relate to your degree major, and the employer that you'll be working for has to be registered with E-Verify. So this doesn't work if you're not, this won't apply if you're not working or if you're not already employed. And then, having your employer register with E-Verify if they're not already could also be a challenge. So it's something to be aware of. Generally speaking, there are, for OPT, you are allowed to have 90 days of unemployment. So for those of you who are, in that phase, you're eligible to have that much. And then for those of you who are doing the STEM extension, 120 days of unemployment. And so it's a good idea to keep track of your employment. Some people, kind of work, you'll intern with one company for a couple of months and then another one for a couple of months. And if you're not getting paid, the best way, I can think of to keep track of it is to get letters possibly from those companies that you've worked with, just saying, so-and-so, this is to confirm, so-and-so volunteered, or was an intern with our office 10 hours a week from X date to X date. Those are the types of things I would, you can do to keep track of it. I would also advise that you stay in close with your international student office. A lot of the office, the school officials who are keeping track of this, you should build up a relationship with them so that you can let them know if you have work here or there, and they can also keep track of it for you. Some international student offices are more strict than others and will keep tabs on it a little bit more closely than others. But just because they're not keeping track of it doesn't mean that you shouldn't, because it could come up at a later point when we do the H-1B, or another time when you have a visa interview abroad at the consulate and they find out really you were on OPT and you were unemployed for 6 months, or they say that you were. It's really nice to be able to have if you don't have pay stubs, at least letters verifying that you were working. Another quick point about OPT, again, I'm giving this general information. The best thing to do really is to talk to your school, because they usually have, I think, workshops and things like that, informational meetings to help you guys, to help guide you in applying in terms of deadlines and dates and all of those things. So it's a good idea to check with them, because, and then usually they help you file for it. But I'm reminding you guys not to, please don't forget to apply. Usually, this is a general guideline, 90 days, the earliest you could file is 90 days before your program end date, or 60 days after the program end date, and any time obviously in between. You should always check with your school for the exact filing dates. There's been some confusion recently, so it's definitely a good idea for you to check. But either way, you should always apply, whether or not you plan on staying in the U.S., if you plan on going home, if you haven't even thought that far in advance, whether or not you have a job offer, you should still apply for it. And then if you don't end up using it, or if things change, you can make that decision at that point. But I really do think it's a great idea, because who knows, and what happens is a lot of times people all of a sudden, it's too late and a job offer comes up, and it's really a lost opportunity. So I highly suggest applying for your OPT. And then it's also good if you do want to stay long-term, because it gives you this 1 year of work authorization where they don't have to sponsor you for a visa. So then you get a feel for the employer, they get a feel for you, and hopefully after that 1 year, you can, what I say here is use it as a stepping stone. But at that point, after the 1 year, as long, maybe things are going really well, they'll want to sponsor you for the H-1B or a different visa, and maybe at that point you're not happy and you want to move on anyway, but it's always a good idea to kind of have that flexibility. So after OPT, which is, a lot of you, whether you're in that period or about to enter it, how it normally goes is you have 1 year of OPT, and then you have the H-1B visa, which is the professional occupation visa. What is a professional occupation? That's a great question. Anything, we would think is professional, but the USCIS has very strict guidelines, and Department of Labor too, I should add. It's a job that requires a bachelor's degree at a minimum to enter that field to perform the job. So some occupations, you prefer a bachelor's degree, and then others, actually require it, or they require higher. It just depends. But some examples are just, some generic examples are the financial analyst, accountant, software engineer. These are the more professional occupations. Unfortunately, things like, a production assistant or any sort of assistant, position, or anything that's too administrative, we have a harder time finding a classification that would qualify under the H-1B. So it's definitely something that you want to be aware of. But usually, if you have an attorney helping you, it's really based on the job duties rather than the title. So even if it has a less professional sounding title, the duties could be very sophisticated. So in that sense, we would probably focus on really highlighting the sophisticated duties. Just a few quick points about the H-1B. It is employer-specific, meaning you can only work for the employer that sponsors your H-1B visa. You can work it can be for part-time or full-time employment, and there are, some minimum hourly requirements, but that's also an option for those of you, or if you have an employer who doesn't necessarily need a full-time employee, they could hire you part-time and pay you hourly. You can have a concurrent H-1B for multiple employers, so if you have two part-time employers who would like to sponsor you, a lot of times people have that, especially in the medical field. And then there is a 6-year maximum, and each H-1B is granted in 3-year increments. The next point is, the H-1Bs are at-will employment. So a lot of times another big question is, we're filing for 3 years. Does that mean I have to stay with this employer for 3 years? And on the other side, the employer is always asking, do I have an obligation to keep this person on for 3 years? No. Yeah, it's at will. So as long as, the employment relationship exists, then they have an obligation to pay you the prevailing wage, but you can leave at any time and they can terminate you at any time. You can also transfer yourself to a new employer by filing an H-1B change of employer. So there's this thing called portability, and that way you don't have to worry about the cap again. And I'll discuss the cap coming up very soon. So just these are some general points I wanted to talk to you guys about. Okay, so there's the H-1B quota, and luckily enough, it's February, what's the date? February 6th, and we have the April 1st deadline coming up, which our office is getting a little bit busy talking about and thinking about and getting prepared. There is something called an H-1B quota, and it's based on the fiscal year, and that means that there's a maximum. There are 65,000 per fiscal year, 65,000 regular, a bachelor's degree, based on bachelor's degree H-1Bs available, and 20,000 visas for U.S. For U.S. graduates with a U.S. master's or higher. So it's about 85,000 visas that are released every year, and so the earliest you can apply is April 1st. Basically, what has, just to give you some history for those of you who are new to the game, before when we were filing H's, April 1st, we used to call March Madness, not in the same sense as basketball, but for H-1B purposes, that was the craziest month for us because, hundreds of thousands of people were all trying to prepare their H-1Bs and have them filed on April 1st. So we would send them out on March 31st for delivery on April 1st. And there would be, they would receive, 150,000 applications for those 85,000 slots that I'd mentioned on the previous slide. And so at that point, everybody would file that first week. They'd have a computer-generated lottery and would just randomly select petitions, and the rest would be sent back. And it was a lottery, so those people, were kind of out of luck for that year and would have to wait for the following year. And then basically, since the economy kind of took a turn, the last 3 years, actually I see I think there's a typo here. Oh, no, that's fine. The last 3 years, it's opened on April 1st and stayed open until, in 2009, it was December, so that was a good 8 months, and then January, November. And then a funny thing happened last year. The cap was reached in June, so about 2 months after the cap had opened. So all of a sudden, it had gone back to, gotten closer. It wasn't, April 1st or anything, but, clearly things had been changing, and, I don't know if the, conditions, hiring conditions, and the economy has improved, but it was the shortest H-1B filing season ever. And then recently, we've, kind of seen increased hiring. So we're, for this year, also predicting a very short cap season, probably even shorter. So we're suggesting for those people, for our own clients, people who are ready to go ahead and try and file on April 1st, obviously as soon as possible. But anyway, so that's something about timing. That's always a big question for people. And it's really difficult because, and I think it'll, I'll get to the next slide in a second, but the April 1st date kind of puts people in a funny spot if you're just graduating. So if you haven't finished your degree requirements and you're just graduating, you wouldn't do the April 1st. I mean, you probably wouldn't be able to, but you have OPT, so that would carry you until next year, and next year you would file, by April 1st. So that's something to keep in mind for those of you who are worried, who are just graduating. Just make sure you file for OPT, and then you can file for next year. One of the things that also changed over the last few years is something called cap gap relief. Basically what it does is, as long as you timely file your H-1B petition, that has to be on or after April 1st, since that's the first day you can do it. But if you file it before your OPT expires, your work your status to be here automatically extends, but your work authorization also automatically extends, and you can continue to work through the summer for the employer until September 30th, until the October 1st start date, because for H's, you file April 1st, but it's an October 1st start date where it actually, your status changes from F1 to H-1B. So anyways, CAT gap relief is really, really important for those of you who have been on OPT for the last year, and perhaps your OPT is expiring this summer. You would need to make sure that you file the H-1B before your OPT expires. I have a little map here, and this is based on somebody who graduated last year in 2012. So let's assume somebody graduated last year in May of 2012. They got their OPT sometime in the middle of last summer, so let's say July 2012 for 1 year. So they have a 1-year work authorization until July of this year. What would happen is they would file on April 1st or as close to that date as possible. And since they're filing before the OPT expiration date, their F1 status and their work authorization automatically extends until October 1st, which is when their H-1B would start. If they didn't file, let's say, for example, before the July expiration date, assuming there are still visas available even after July, which, if last year they ran out in June, that wouldn't happen. But, for example, if, in this hypothetical, let's say they file after the expiration date, they could continue to be here until October, but they couldn't continue to work. So, for August and September, they'd have to take a leave of absence from their job. And a lot of times, obviously an employer, that doesn't make them that happy. But, some, depending on the circumstances, they could probably be okay with it. Or they would be. If for any reason you're not, let's say that there is, whether it's a lottery, if they receive a lot, or if for some reason your H-1B petition is denied, you would get it. There would be a 60-day grace period from the date of notification. So it wouldn't backdate all the way back from when your OPT expired or when you filed. It would be, usually it's from the date of notification, as long as it's not, a frivolous filing or fraudulent or anything like that. If they find that, if it was legitimate and in good faith, then you would have that 60-day grace period still. Okay, so basically the process itself, which is another popular question, the agencies involved it's 2 steps. One is the Department of Labor, and 2 is USCIS, U.S. Citizenship and Immigration Services. First, what happens, we have to verify, the company's tax ID number, and there's also an LCA, which that is also, those are both, kind of confirmed and submitted through the Department of Labor. Once those are done, then those 2 steps are done, we can go on to the USCIS steps, which is the petition itself, the support letter talking about what you'll be doing, your job description, and all of those things. And then once everything, we have everything, then we would file it. Generally, comfortably, it would be nice to have, several weeks to a month to prepare an H-1B petition. That's not always the case, but at the very least, I think, any office is probably going to need at least 2 weeks, even if it's a super tight timeline. Because the LCA itself takes 1 week of that time. So it's a good idea if you are thinking about doing it to get started as soon as possible. But also at the same time know that there are some options and there is some flexibility. A couple other points about the employer obligations. They are obligated. They must pay you the prevailing wage, and you can find the prevailing wages at the link I give here. And it's basically broken down per category. So accountants in Los Angeles, entry level, level 1 should be paid at least X amount. It's really broken down in that way. So it's really, that's where also the job description comes in handy, because we have to look it up when we're filing the application. And they tend to be a little bit, to be honest, they tend to be a little bit higher probably than what most people are currently earning. I don't know, what the policy is behind that. Some say it's because they're, they want to make it harder for U.S. employers to hire foreign workers. I don't know. It's all speculation, but they do. And so sometimes when people look, they're like, no way, no one else, that's preposterous. No one else gets paid that much. But, these are the wages that are set by the Department of Labor, and we're kind of, obviously obligated to follow that. And if you want an H-1B, the employer has to pay you that wage. There's no benching. So, for instance, because they can't pay you, they can't just kind of say, you can't work or like make you go on leave or something like that, so they don't have to pay you. If you are terminated, the employer must offer reasonable costs of transportation home. They only have to offer it that one time, initially when they're laying you off. And then, beyond that, they don't have to offer it to you again, or if you say no, they don't have to pay for it no matter what. They just have to offer it that one time, and if you say no, then that's it. They don't have to pay for family members. And then the company is also required to notify USCIS, so that's something else to be aware of. A lot of times people think that they have this, flexibility, or no one will know, and there are reporting requirements. I mean, whether or not they do notify USCIS, that's up to the employer, but these are the requirements. Okay, the big question, who's responsible for all the fees? How much and who's responsible? The H-1B is highly regulated and enforced because it does have the Department of Labor involved. I think that has a lot to do with it, and there are a lot of rules. There's some flexibility as well, and it all depends on how much you're being paid. A lot of it does. So as long as you're being paid above the prevailing wage enough so that you can help with some of the costs, for the most part, it's not an issue, with the exception of the training fee, which is one, that absolutely has to be paid by the employer. There are other government filing fees, the fraud fee. Some people say that it has to be paid by the employer, and some say that it can be paid by the employee. Either way, no matter what, if you are going to pay any of the fees that you're allowed to pay, you have to be paid at least that much above the prevailing wage. So I have an example here. Let's say the prevailing wage, you're an accountant in Los Angeles at $60,000, and your salary is also $60,000. If that's the case, you can't pay for any of the legal fees or the government filing fees because your salary would drop below the prevailing wage. So it's just kind of an example. Who will know? I mean, a lot of times, the employer can't require you to pay, or, you can't offer the employer to pay and then you pay them back, or they take it out of your paycheck later. Those kinds of things I really don't advise doing. It could come up, you never know when, but and where. A lot of times at visa interviews, if you, at some point in the future you need to go abroad and do the H-1B visa, I mean, they can ask you, and then, so anyways, it's just stay away from that. But it's a good idea to have an understanding of who is responsible. And this brings me to audits. Like I was saying, this is a heavily enforced area, both on the employer and on the employee side. There has been an increase in fraud investigations and worksite visits. I get calls, excuse me one second, please. I get calls a lot from clients where, they had somebody stop by. They are like, oh, I had an officer stop by, and they wanted to find out where so-and-so was working, what they were doing. They asked to see payroll records. I mean, and it's all within their rights. When this petition is being filed, they do come and check in and make sure that you are, you're not actually answering the phones or, doing something that's not what was listed in the petition. So that's something to be aware of. And, they've hired some investigators. And one of the, the fraud fee that's paid, that's actually paid, to the fraud detection unit. So that's basically, you're included in the H-1B fees as a fee for them to check everything out. Okay, so hopefully for everyone, that's listening, you're either about to graduate and do the do OPT H-1B. For some of you, maybe you've missed that window, or maybe it's for next year. Or some of you who maybe will miss it this year. You're going to file as soon as possible, but maybe, for instance, it has the cap is met that first week. I hope it's not, but let's say it is. So what are your options other than H-1B once you're finished and you no longer have OPT? There is a way to file. There are H-1Bs available for cap-exempt organizations. So you would, for companies that are not subject to the cap, and these are mostly, universities and colleges, nonprofits, nonprofit research organizations, and they're very specific about their definition. So it can't just be like any nonprofit. It has to be like a nonprofit research organization, or here I've listed, a nonprofit affiliated with an institute of higher education. But for some people who are doing, research or want to go into that, this is a great option because there are lots of organizations that aren't subject. So you can apply for an H-1B at any point. You don't have to worry about April 1st, October 1st. You would have to work. So let's say you do that, and then it's something to be aware of. You would be subject to the cap if you work for, like, let's say a university, and then you decide to take a job in the private sector. You would be subject to the cap at that point in the future. Obviously H-1B extensions are not subject to the cap, so once you do get it that first time, beyond that you don't have to worry about the cap because you've already been counted. So it doesn't apply in that situation, or if you change employers or anything like that after you get that first one, you don't have to worry about the cap. And there's also something called an H-1B remainder option. So if you've previously held H-1B status, for those of you, some people, they had an H-1B after they finished college, and then they worked for a couple years, they went back to school and got a master's degree, finished, and now you're re-entering the workforce with a master's degree. If you've already had the H-1B, you would not be subject again, and so you could reuse, or not reuse, but you could use the unused portion of those 6 years that are still left over. So if you worked for 2 years, you went to school for a couple, now you still have 4 years that would be that you'd be able to recapture. So there is a 6-year cap, and not to be confused with the cap, but there's a 6-year max, which is probably more appropriate on the H-1B. Is 6 years really 6 years? It is for the most part, with a couple of exceptions. You can recapture time spent abroad. So for those of you who are just starting on your H-1B journey, you would want to, starting from the beginning, keep track of all of your time spent abroad. So that includes all of the, trips anytime you leave the U.S. So whether it's going to your home country or going to, Canada or Europe or somewhere else on vacation, you should keep track of all of that time, because more often than not, when we ask somebody about this, they're like, oh, I don't have that much time. I mean, yeah, sometimes I would go home. And then we'd really add it up by, through itineraries and passport stamps. And you'd be surprised. I mean, some people recapture, 6 months up to a year. You never know. And whatever it is, it's nice to have that cushion when you're, towards the end of it, and you're in the green card process, and you're trying to, look for other ways to extend your H-1B. It's just something nice to keep track of. So I recommend keeping track of it from the beginning. So a couple ways, to extend the H-1B is if you basically, and these are different steps within the green card process I have listed here, but as long as you have, one of these two things, then you would be able to, and this is to help people who are in, whose categories backlogged or in retrogression, so that people who are, kind of backlogged for many years are able to continue to extend their H-1B while they're waiting for their priority date to become current. I know that's kind of technical stuff, but I just wanted you guys to be aware of it. There is a way to extend beyond, and so, this is something that's there. Here's some top 10 myths about the H-1B visa. You can have an H-1B for a small company or a startup. You can, and it's a little bit tougher. They could issue a request for evidence, and they could give you a hard time, but it's definitely possible, especially if it's a if there's a good business plan, you have some good funding. We have companies like that all the time where they're kind of based on research, so they have $1 or $1.5 million in funding to start up, and then kind of the company grows. So it's definitely a possibility. The only issue, in addition to being able to, the thing about money is they want to make sure the company has enough money to cover overhead, so all of the salaries that would be involved, including yours, that they can pay you the prevailing wage. but also they want to make sure that if it's a small company or a startup, and we're saying that you're going to be the, I want to give you an example, marketing manager of the company. If they're only, let's say 2 or 3 employees and you're the marketing manager, chances are you're probably also sometimes answering the phone, sometimes preparing FedExes, sometimes doing kind of admin stuff that's not necessarily a part of the marketing manager job description, which, I mean, is something that's common, which we all do if you're in a small company, everybody pitches in, but that's another kind of hidden risk that comes with the filing with the startup, but it's doable. You don't have to advertise for the H-1B position. That's something that has to be done with the PERM green card application. There's the recruitment where there's the Sunday ads and all of that. A lot of times people think that's with the H-1B visa. There's an internal posting where the company has to post something within the office that they're hiring somebody in this position, but there's no, kind of newspaper advertising. You can change your employer if the H-1B cap is reached. So if you have a pending H-1B, you would want to wait for that to be approved, and then you could change your employer in the cap, or you can change your employer. You don't get a new 6 years if you change your employers. You just get that 6 years with the exception of, you can extend it with, I gave you some exceptions before, but if you have a green card application filed at some point before and certain criteria are met, you can continue to extend it. You can go to school part-time on the H-1B, which is nice for some people. They like to be able to do that. And you can't file, and this is kind of relevant for those of you looking at the cap, you can't file under the master's cap until you complete that higher degree. So if, for those of you, let's say if you want to file on April 1st, your degree requirements have to have been fulfilled by April 1st, and you're basically just waiting to walk on, whenever, May 15th or something. And you can, get that. Some people graduate, and some of you may have finished in December, and that would, so then in that case, we could possibly do it. We would need a letter from the registrar specifically stating that all degree requirements have been met, and the only thing that's, kind of waiting is like the actual ceremony. If for some reason that doesn't work, we would just file under the bachelor's cap, which is still fine. Using premium processing does not lock in an H-1B number. It doesn't mean your case is going to be approved. In fact, it probably means there's going to be a request for evidence. Haha, I'm making an inside joke to myself. Not necessarily either, but it doesn't do anything other than, make it so that the petition is adjudicated much quicker, which some people need for peace of mind. But for those of you who are on OPT, and if you, timely file it before your OPT expires, you can continue working anyway. So it doesn't really matter, but some people need it in case the processing times get too long, because if you don't have the decision by September 30th and your OPT is expired, you have to be taken off of payroll until you get the approval, which is kind of a weird situation to be in. So that's where that comes in. But that's something you can strategize with the company and with your lawyer. This is a funny one. No one will check if you're actually working in the H-1B position. That's not true. Like I said, they have work site visits, and then there are all these different, different ways and times that it would come up. So I recommend being as, on the up and up as possible with these petitions and keeping that in mind as well. Everybody has a friend who's done something, but, it's not worth it. If I were you, it's not worth it. And then last one, filing multiple petitions with the same employer. And that was an old one. That's from, like, in the case of lottery, where what some people would do, they would file, like, 5 petitions with the same employer to increase their chances of selection. Okay, so for those of you, I know most of you are students, but some people have families and want to know what their spouses and children's options are. So with the H-1B, your spouses and children have the H-4 option. There isn't employment authorization yet. It's something that they're working on, maybe sometime in the future, but they can go to school and and they can continue to be here as long as you're continuing to be employed in the H-1B capacity. Okay, some other alternatives to the H-1B. For those of you, there are certain country-specific visas that are available, so I'll just kind of run through them quickly. And again, if you have questions, specific questions about any of these, feel free to email me separately, and I can, obviously try and give you my thoughts on it. There are H-1B ones for Chileans and Singaporeans, which is really nice. And they seem to always have visas available, so if this applies, that's good for you. There's the TN NAFTA visas for Canadian and Mexican nationals. The TN is very similar to the H-1B. It's all about a professional occupation. The good thing about the TN is that there's no cap or quota. You don't have to worry about it. You can apply at any time. But on the, a con on the TN list is that there's a TN appendix, and they're only a very limited and specific number of occupations that are listed in the appendix. So sometimes, while it's great because it's easier in some regards, it's sometimes a little bit more difficult because they're very limited in the occupations that are listed there. But it definitely applies. There's economist, graphic designer. There's one called a management consultant, which a lot of people try and use, which you have to be very careful with. But there are options, so that's good. And then for Canadians, it's even easier because they can just apply directly. I mean, you prepare the application, but you apply directly at the border. Upon entry, you just hand it to the CBP officer. And for Mexican nationals, you take the application and you just apply at the embassy in Mexico. And both of these are great because that means there are no filing fees, which is really nice, considering the fact that the H-1B filing fees can be almost, I think like $2,000, $2,500. So you can save on that if you are Canadian Mexican. For Australian professionals, there's the E3 visa, which is also very similar to the H-1B, and similar, just like the TN, and the H-1B requires a bachelor's degree and someone with who's coming to be in, work in a professional capacity. And the E3 is also really straightforward for Australians. We prepare the application and they present it directly at the consulate in, in Sydney or Melbourne, and the visa's adjudicated right there on the spot. No government filing fees, and very straightforward. For the E3, spouses get work authorization, so that's something to think about. For people that are currently abroad right now, another option is the J1 for exchange visitors. So it's an intern trainee, and then there are different classifications within the J1 because there's the intern trainee side of things, and there's the professor research scholar. And so there are different requirements, but basically, the J1 really requires a foreign degree, so it won't apply for those of you who are here as an F-1 student. But it's just, I have included it for general knowledge. Here's the J1 professor research scholar. That's a little different, and so you have to, obviously speak to the school, but there's something to be careful of. Some J1 visa holders are subject to a 2-year home residency requirement, meaning they have to go home for 2 years, and sometimes it'll be annotated on the person's visa or the DS 2019. Another alternative is the H3. It's for a trainee, and again, it's a little bit harder once someone's already been here in F1 status and done their OPT, which is supposed to be optional practical training, to then apply for a training visa. So this kind of, really doesn't apply for people who are here, but sometimes it has worked. If you can show that the training is not available in your home country and you plan on going back to work to your home country to carry this skill set over, then it's a possibility. Another option for those of you who have a lot of employment experience at home, maybe this could be an option, or for those of you who may have gotten job offers to work for a large company. Some people who are in business school, for instance, they get job offers to go work for, let's say, IBM in Buenos Aires or something. it might be an option because of this L visa. What this is basically it's for executives and managers is L1A. L1B is for specialized knowledge. So as long as you can show that you have spent 1 year, you have to show 1 year of employment abroad with a related company. You have to show the the corporate relationship, parent, affiliate, subsidiary. If you can show that 1 year of employment, you can be transferred back to the U.S. as a manager, executive, or specialized knowledge employee, and you have to be coming in to be doing that. But it's a good option for some people, to go work abroad for a year or two with this option. I mean, it's not obviously guaranteed, and it's up to the employer whether or not they want to transfer you back to the U.S. But this is a really great option, and really, it's for multinational, it's for global companies, larger companies, but it's also for smaller companies. If you had a company, that you had abroad, or if you, have one and then you want to set an office up in the U.S., there is also something called a new office L1 petition that I'm more than happy to, discuss later. So there are definitely there are some options. And just really quickly, you have to show the 1 year of the immediately preceding 3 years. So again, for some people who have been in school for the last 4 years, for instance, it's not going to work. So that's where it can't be 5 years ago I worked for this company for 2 years. Can they transfer me? No, it has to be one of the last 3 years. Yeah, so here I have the new office L. It's only good for 1 year. The L1A is good for a total of 7 years. That's for the executives and managers. L1B, total of 5 years. Spouses and children receive L2 visas, and spouses receive work authorization, which is nice. They get a work permit, and there is a green card, the EB-13. Again, it's for really for executives and managers, high-level people, but it's a really great option if this is something in terms of looking at the big picture, and when you're deciding whether or not to take a job offer. This could be something. For those of you who are more entrepreneurial, there are actually, and I haven't included this in the slide, so I haven't updated it, but recently USCIS has really made a push for, trying to create some options for entrepreneurs and for people who are looking to establish businesses in the U.S. And so hopefully that'll mean that there will be, I don't know, just maybe a little bit more flexibility for new businesses and new business people in the U.S., and they've just, expressed an interest in this. So it's nice. But, in terms of the visa option, there's an E1, E2 treaty trade and treaty investor visa, and that's for somebody who wants to set up a company in the U.S. You have to have a treaty. The one caveat is not everyone is eligible for this type of visa. There has to be a treaty between the United States and your treaty country. And I gave the the link at travel.state.gov. There's a treaty country list that you can check to see if your company is on. Not your company. Your country is on there. And then if so, this could be an option for you where you can either purchase a company or you can start up your own. There are some requirements. I'll go here. The trade. For the trader visa, it has to be 50% trade between your home country and the U.S. So some people are interested in import-export, and then the investor visa is really somebody who you want to set up a production company here, or you want to start a restaurant or a clothing store or something like that. You can do that, or you can buy a company or buy into a company that's already in existence and show you own at least half of it. So that's the option for those of you who are business savvy. Spouses and children receive dependent, pretty much across the board. I mean, all spouses and children receive dependent visas. You have to be legally married. You have to show marriage certificate and birth certificate. It's the work authorization that not everyone gets, but the E visa, just like the L, as well as the E3, also has work authorization for your spouse. Okay, so for those of you who are possibly in the sciences, education, business, the O1, down the line, probably not right now, actually, but I mean, I don't know. I don't know what your qualifications are, but I also prepare a lot of O-1 visas, and these are really for aliens of extraordinary ability, and the different classifications within it. We, being in Los Angeles, we do a lot of motion picture TV type stuff, but there's also the O-1A, which is the higher category for people in science, education, business, or athletics. So like, researchers or really high-level business people, professors, coaches, that kind of a thing would fall under, and I write here in parentheses, and fashion models. They fall under the business category as well. And then there's the arts and motion picture TV. And within the arts fall people who, graphic designers can fall in this category, like a sound engineer or something like that. So, it's pretty broad. I mean, a lot of things can obviously fit into these categories. The problem being, and I'll get to the next one, is a standard. So you really have to show that you have kind of gotten to a good level in your career. So again, it might not necessarily be something that you have now, but it might be something you have in 5 years or something. So the O-1 visa is really good, and I have it broken down into the different standards. But it's, extraordinary ability, high level of achievement. And here are some types of evidence. People are always asking how much and all of that. But, if you have a lot of, like, let's say it's really by occupation. So let's say you are a researcher or a professor. It's really going to be about your publications, your citations, your invitations to different international conferences, being asked to be a reviewer or judging the work of others, and publications in journals and any sort of, grants that you get for your research, those types of things. If you are a, business person, let's say you're this like super high-level business person, maybe you've had a lot of articles you've been interviewed on, CNN, or you can show you get paid $1 million a year for the last 5 years, something like that. So those are the types of things. Again, it is a really high standard, but it is something that people, oftentimes are surprised that they, possibly could qualify under that category as well. Just some general job search tips. I know I'm going to get to the green card options very soon, but for those of you who are still listening, job search tips. I mean, the internet is great, I guess. Everyone knows that. So social networking sites, everybody knows, your school career services, local chamber, your chamber of commerce, and local embassies and consulates. A lot of times, people who are from a certain country want to go to their consulate and say, oh, I really, they want to help out their community, and they may want to hire, somebody who speaks the same language or to help, So that's always a good idea. And, something in terms of people ask all the time, what should I say in an interview and all of those things. I mean, I would just highlight your international perspective. I think that's really valuable, and it gives you a competitive advantage over other people because you have a different perspective, and it's just adding to the diversity to the office, cultural diversity, and it's a global economy. So those are the things you should really highlight in terms of, visas and all of that. I know it's always a weird situation, but it's something that, you should probably try and be as upfront about as possible. So that's your, your choice. And, a lot of times, especially larger companies, they're very, very well-versed and comfortable with the visa process. So it's not as intimidating as a lot of people think. Green card options, our grand finale, and I'm going to skip over a lot of the more technical things towards the end. And again, if you have questions, please feel free to email me separately. It might take me, a little bit to get back to you, but I will respond. I will try and get back to each and every inquiry. So, feel free to ask later. But green card is obviously, something that a lot of people who want to stay here are working towards, and that's to become a permanent resident. It's not citizenship, but it's to become a permanent resident. One option is the green card lottery, which I have here in big red letters. It's closed right now. The registration period is October to November of each year. So hopefully a lot of you, everybody who's listening right now, went to this website. If you're eligible, if your country is eligible, you registered. I really hope that you did. There's no application fee. You don't need to pay someone else to do it. It's free. You kind of upload your picture and you fill in your biographic information. You do it all online. It's really straightforward. So if any of you didn't do it this past fall, please make sure you do it this year and every year. We always have people who contact us and like, oh, I was selected for the lottery. Even now I've had people tell me that they were selected. They notify you, if for those of you who did apply, in case you did, they'll notify you starting in May. So you should look out for that, and I think you can just go online and check your application status. Green Card Lottery is based on country of birth, not citizenship. So that's always something people don't realize. They may be eligible because it's based on birth. And then I've listed here the countries that are not eligible. So it's unfortunate, but it's just the way it goes. You can cross-charge to your spouse's country of birth. So even if you're not eligible, but your spouse is, then you guys can file an application under your spouse. Okay, so the next option, basically there's Green Card Lottery, family-based, and then employment-based. So the second one is family-based green cards, and that really is based on having either, having an immediate relative, spouse, parent, kids, who are either U.S. citizens or green card holders, and there are different categories within the family-based green cards that you should check to see for immediate relatives. So that would be if you're a student and life happens, you meet somebody while you're in school, you're dating somebody who is a U.S. citizen, you guys want to kind of go down that road. If you get married, then you would file a green card application. Within about 2 to 3 months, you get work and travel authorization, and probably within several months after that, there is an interview where they really do ask you questions, talk to you, make sure it is a bona fide real marriage, and ask you guys questions, and they ask you to produce documents and all of those things. So they really do look into this. So I don't recommend doing this unless it's real, obviously, but there's a conditional green card that they give to you if you've been married for less than 2 years. If you're married for more than 2 years, you get the 10-year green card. And then so other options, if in terms of an adult child, this is a very, very common question. Some people are like, oh, I have a baby who was born in the U.S. Well, the baby has to be, once your child becomes 21, then they can sponsor you, but not before. So it's a long wait for some people. I've listed some of the other categories here, siblings of U.S. citizens. It's there's a 12-year backlog. And these are just, the visa bulletin is published each month. So you should, check it. It's constantly updated and changing. And so, I've listed some years here, and these are approximate years given based on all the backlogs. But, it's all listed here. And again, you can go to travel.state.gov to find out what the different categories are. So I, kind of went through the family option, and then, for most of you, it's going to be employment-based immigrant visas. So immigrant visa is really the green card option. It's an immigrant visa petition. And then employment-based, we refer to employment-based green cards EB1 through EB5, and it goes from basically highest and quickest to, well, EB1, EB2, EB3 at least, and then 4 and 5 are just separate, different categories. EB1 is first preference. This is going to be quickest processing times, and this category is really for kind of the O1 people we were talking about earlier, the aliens of extraordinary ability, outstanding researchers, professors, and then the executives and managers. So really, high-level people who have, really made huge achievements in their field and in their careers. And incidentally, EB1, a lot of entertainment people also fall under this category, EB2 is second preference, so it's employment-based too. And this is for advanced degree holders It's, basically for if you have a master's or higher, or if you can show bachelor's plus 5 years. And there's also a category, SCED A Group 2, that's here, aliens with exceptional ability. And then there's the national interest waiver petition process, which is also included in the EB2 category. And then the third category, which is the slower one, which everyone hears about with the backlogs, is the third preference category. And this is for basically everyone else who has a bachelor's degree, skilled workers, and then further down. EB2 versus EB3, why does it matter? So EB1, clearly, you have to qualify. You're at the higher levels, or you've just been working in the field for a really long time. EB2 and EB3 is what, is usually, the perm-based, which is the recruitment that I was talking about earlier, where they have to advertise for the position. And that's the classic context I'm going to talk about here. But in terms of why does it matter, because of retrogression. The processing times are much different. If you look at the visa bulletin, which I just referred to, and it's actually coming up in the next slide or two, you'll see the difference in time. And the most backlogged countries are China and India. And again, I'll show you the visa bulletins coming up. But this is for, and I'm just going to speak specifically towards the PERM labor certification process, which is part of this green card. This is where an employer would sponsor you, and this is where they have to do, conduct good faith recruitment and show there are no qualified U.S. workers to do your job. So it's kind of a weird thing. They actually, the employer is required to advertise for your job, and then once they've shown no one else can do it, then it's then they file all this paperwork and it's certified, and then there's step 2, 40, which kind of shows the company's ability to pay your wage and discusses the application a little bit more, or the position a little bit more, and the job offer. And then step 3 is the adjustment of status, and step 3 is where the work and travel authorization comes. So what happens is when there's a backlog, you're able to file steps 1 and 2, but you can't file step 3 until your priority date is current, and that's where a lot of people fall in the backlog. And so that's why people need to extend their H's for after the 6 years, because they're waiting to become current. And for some people, it's 6 years, 7 years, whatever it is. And so I pulled this off of the February 2013 visa bulletin. So you see EB2, all this C's here means current. So that means you can file everything, the adjustment, everything's fine. EB2 is okay except for China and Mexico. So there you can see there's a backlog of EB2, 8 to, I'm getting used to the new year. So it's like a 5-year backlog in the EB2 category, and for Indian nationals, it's, wow, it's like 9 almost, or a little, like 8 years, 8.5. And then the EB3 category, you can see, is actually substantially, obviously slower. So that's where it makes a big difference for people which category their job is classified under. So deciding, between these two, it's not based on your background. It's not because even if you have a master's or a PhD, it doesn't necessarily mean that's the classification your PERM application will have. It's based on the minimum requirements for the job that's being advertised for. So that's up to your employer, really, because if they want to hire, if they want to post for your job, or they want to sponsor you, let's say, for instance, they have to say, okay, the minimum for this job is a master's, let's say a master's degree plus 2 years of experience. And if that's what they say, that's what it is. I mean, hopefully you also meet that. But if for some reason your employer is like, you know what, no, I mean, I can't honestly say a master's is the absolute minimum requirement. Somebody with a bachelor's could also do this job. Then it would be classified as an EB3. And then, or what they can say is, oh, it requires, a bachelor's plus 5 years of experience. That would qualify as EB2. So it just kind of varies. But there are some tricks, that don't work that people are always trying to do is, kind of tailoring it to you, the specific, the person, or trying to add, for instance, foreign language requirements. unless the job is like a translator, you can't just, kind of arbitrarily say like, oh, I want this person to, this person needs to speak French, especially like, let's say they're not French clients, there's, nothing to do with it. Or even if there are French clients, then you would have to show the business necessity. Actually, that's where that would come up. But you can't tailor it too much, and then if you make the requirements too tough, on the other side, when you submit the prevailing wage request, they're going to come back and say, okay, then this person should be paid, $150,000 a year. So then it'll be too high. So it's a really balanced effort, and it really does need to be done in good faith. So, anyways, and another quick point is you generally can't use employment experience gained with that employer. That's just one of the rules that apply. So let's say you want to try and get into the, they want to get into the EB2 category by using bachelor's plus 5 years. For those 5 years, that 5 years of experience has to have been gained before you started working in the current job with the current employer. So that's something to keep in mind for some of you. And then you can't use unauthorized work. Unauthorized work, you can't use that. When to start it? I mean, obviously you can start it at, at any point when once you start in the H-1B process, or, once you're with the employer and things are going well. But we typically recommend somewhere in that 4th year of your H-1B, that's when you should get started, because in order to extend it beyond that 6 years, there are certain things that need to take place and happen. So you want to make sure that you've allowed enough time, and that's a good time for around the 4-year mark. Obviously, you can start sooner if you guys agree on it. Just the last couple options, and we'll kind of wrap this up soon. There's the EB4 religious worker visas. Well, the religious worker visa is an R1 visa, but there's a religious worker green card option as well, under the EB4 category. And they're very strict about that. So it should needs to obviously be totally legitimate. And then the EB5, which is something that a lot of people have probably heard about, or you've heard about, where people are like, oh, you can buy a green card. I mean, not really. You can't. But in terms of investment, you follow the right steps. There are 2 types. There's the $1 million investment, where you make a $1 million investment in your own. You want to do your own company. And then there's a $500,000 one, $500,000. The second one is for our regional center programs, which the lower amount, I mean the $500,000. It's a pre-approved program. It's a pooled investment, meaning, it's passive. You don't really have a whole lot of say in it. And it's, for people who live in LA, like, LA Live, it would be like some large thing where it's a lot of people who, you put money into it. I don't know what the return rate is. It varies from program to program. These are all programs that are designated by USCIS. But these are great options for those of you who have generous family members or who have done particularly well before. You do have to show where the money comes from, so that's something to keep in mind. And I'm going back and forth. But I think what happened now is that concludes the presentation. And at this point, there have been a lot of questions that have been typed up. So rather than take up anyone's time, I would probably prefer to respond to you guys individually for those of you who typed up questions. And then hopefully I was able to kind of give you guys a brief overview for those of you who have employers and who can have the option. I think April 1st, I mean, that's just my suggestion. I'm trying to do my cases on April 1st if I can, not to send everyone into a panic, because if that's not, it's not it for you, then there are other options. So anyways, feel free to email me at any point. My email address is here, fwittenberg@wolfstorf.com. Our number is here as well. And I thank everyone for joining me, and I hope you found this to be useful. We have these webinars. I think I'm doing them actually kind of, I think once a month through the CAP season, about that much. But you can also go to our website. We have some other webinars on different options and for different, different categories and all sorts of things. So go check out our website and have a great day. Thank you.